Good evening. Can you hear me? Try this one? Yeah. I've only known Justice Sullivan for less than a year. We met last spring in England. But after we'd spent a weekend at a conference and did the do you know thing with each other, we discovered that we should have met at least 50 years before because we knew so many of the same people. His career, however, is distinguished and worth retelling, whereas mine is largely on the private side of the law. I think that Justice Sullivan graduated from Dartmouth in 72. Worked in Washington for a great leader of our Congress, John Bradamus, for several years. Went back to Indiana, where he had grown up to go to law school, practiced law in a distinguished firm in Indianapolis for several years, and then was appointed state budget director of the state of Indiana by Governor Evan Bayh. And after a few years in that post, 4 or 5, he was appointed to the Supreme Court of Indiana in a complicated process that he perhaps could better explain than I can, but appointed by the governor. And has served now since 1993 as a justice of the Supreme Court of Indiana. I think that's sufficient. Justice Sullivan can tell you about his topic himself, so I'll turn it over to him.
Well, thank you all very much for being here this evening. Father Timish, Jim Reed, my friend Tom Joyce, very pleased that you've arranged for me to come to the Eugene J. McCarthy Center for Public Policy and Civic Engagement, and look forward to visiting with you this evening about a theme that I've called Running to Be Fair and Impartial, Can Judges Make Campaign Promises? Because you've been so hospitable to me, I want to lay my cards on the table right from the start. I have a point of view on the subject of my lecture. I'm not here to give you a neutral and detached exposition. I'm going to try to be fair, but I want you to know up front that I have a point of view on much of what I will have to say. I'm not a neutral reporter. And I'm going to ask you to do one thing with me from the start, which I freely admit is designed to help bias you towards my point of view. Normally, if you come to a lecture about elections, politics, and public policy, you come from the perspective, right, of a voter, of a participant in the political process. I want to ask you, if you can, to put aside the role of voter tonight and instead try to imagine yourself as something completely different. What I want you to imagine yourself as is, as you sit in this audience tonight, think of yourself as being a party in a lawsuit in a Minnesota court. You're not a voter, you may be a voter, but what you're worried about tonight is the fact that you've been convicted of a crime you didn't commit and are awaiting sentencing, or you've been convicted of a crime you did commit and are awaiting sentence. Or, if you can't imagine that, imagine yourself a defendant in a collection case, okay, where you've been unable to pay a debt because you've lost your job due to the economy, and you've been sued for the money you owe. If you can't imagine any of those circumstances, perhaps you can imagine yourself as a plaintiff in a lawsuit to try to get somebody who hurt you in an automobile accident pay for your injuries. Or imagine yourself as the head of your homeowners association in a lawsuit to collect unpaid dues from one of your fellow members. Or maybe a parent in a lawsuit to collect unpaid child support from your former spouse, or an unemployed worker in a lawsuit to receive unemployment compensation denied by your former employer. And if you can't imagine yourself in any of those situations, perhaps you can put yourself on the other side of one of these cases. You're the prosecutor of a defendant you know is guilty and deserves the severest of sentences. You've lent someone money and have a contract to be repaid. You've been sued to pay for injuries suffered in an accident you did not cause. I hope you can at least imagine yourself in one of these situations. Now that you're in court, what do you want from the judge? To win? Perhaps. But I think upon reflection, we would all say that what we want from the judge is that he or she be fair and impartial in adjudicating our claim or defense. To be fair or impartial in adjudicating our claim or defense. And let me tell you something that you already know but may not have thought about in just this way. The Constitution of the United States itself guarantees you a fair and impartial adjudication of your claim or defense. Where in the Constitution does it say that? Sarah Palin might ask. Where? In both the 5th and 14th Amendments. No person shall be deprived of life, liberty, or property without due process of law. Our constitutional right to due process of law guarantees us a fair and impartial judge. Suppose the judge rules against you. Should the judge be disciplined or otherwise held accountable? That depends, doesn't it? If the judge did not render a fair and impartial judgment, the judge has violated the litigant's constitutional rights to due process and probably should be held accountable. Let me use 2 examples to illustrate. My first example is from Shakespeare. I warn you in advance, it's a rather gross example. But by using Shakespeare, I avoid speaking ill of any judge who has been alive for the last 400 years. The play is Measure for Measure, not one of Shakespeare's best known. In it, a judge in Vienna named Angelo sentences a young man named Claudio to death for violating a law against immorality. When Claudio's sister seeks mercy from Judge Angelo offers to pardon Claudio if she will have an affair with him. Could there be a greater insult to fairness and impartiality than this? A judge essentially soliciting a carnal bribe for rendering judgment in a particular way. Such a judgment should be held accountable. Such a judge should be held accountable, shouldn't he, for violating due process and punished accordingly, which would be severely. My second example is completely different. It's a true story. In 1931, 9 black teenage boys were arrested and jailed in Scottsboro, Alabama, 1931, for allegedly raping 2 young white women. 12 days later, 8 of them were convicted and sentenced to death. When the United States Supreme Court reversed the convictions in 1932, a new trial was convened for one of the 9, Haywood Patterson, before a new judge, Judge James E. Horton, Jr. The jury again voted to convict and sentence Patterson to death. Judge Horton reversed the jury. He found the evidence insufficient, set the verdict aside, and set the death sentence aside. Judge Horton was defeated in the next election. Here was a judge who provided a litigant due process of law, but was held accountable and punished. Our constitutional right to due process of law guarantees us a fair and impartial adjudication of our case. And the stories of Judge Angelo and Judge Horton teach us, first, that a judge who does not behave fairly and impartially should be appropriately held accountable. But second, a judge should not be punished at the ballot box or otherwise for a fair and impartial decision simply because it is politically unpopular. What I want to talk to you about tonight is how we go about selecting judges who will render fair and impartial justice, and how we go about holding them appropriately accountable when they are not. As a statistical matter, 39 states, including this one and my own, select at least some of the judges in their states at the ballot box. The ballot box is also, as Judge Horton's case sadly shows, a method of accountability. In addition, in every state, the highest court in the state, the Supreme Court of the state, holds judges accountable by enforcing a code of judicial conduct. I think you can see the value of enforceable codes of judicial conduct. They provide a far less severe, a far more calibrated method for policing judges who are not fair or impartial than does the ballot box. So we begin our examination of judicial selection and accountability by assuming we are operating in one of the 39 states that both elects judges and enforces a code of judicial conduct. A few words more, if I may, about the mechanics of these codes of judicial conduct. In states like Indiana and Minnesota, the state Supreme Court enforces the provisions of the code against judges by means of a special disciplinary process. In Indiana, it works like this. Our state constitution establishes an Indiana Commission on Judicial Qualifications consisting of 3 lawyers, 3 non-lawyers, and chaired by the Chief Justice of the state. Allegations of violations of the Code of Judicial Conduct are investigated by the Commission staff. The investigation can result in the Commission filing formal charges against the judge and the case proceeding to a hearing with witnesses and evidence. The results of the hearing are presented to us, the Supreme Court, for a final determination as to whether the judge is guilty of violating the Code of Judicial Conduct, and, if so, what discipline is appropriate. The process here in Minnesota is substantially similar. Judge Anselmo would be removed from office for his misconduct. Judge Horton, of course, committed no misconduct at all. Now, most states' codes of judicial conduct are based upon a model national code of judicial conduct put forth by the American Bar Association with substantial input from judges, lawyers, and academic experts from around the country. In 1972, the ABA put forth in its model code the following rule: a candidate for judicial office shall not announce his or her views on disputed legal, or political issues. Minnesota adopted this rule in 1974. That is to say, starting in 1974, any lawyer or incumbent judge seeking election to judicial office was prohibited by the Minnesota Code of Judicial Conduct from announcing his or her views on any disputed legal or political issue. For purposes of the discussion to follow, I will call this the Announce Clause, the provision in the Code of Judicial Conduct prohibiting announcing disputed legal or political issues. With me? Now, prohibiting a judge from announcing disputed legal or political issues is one thing, but you can readily see that prohibiting a candidate in an election from announcing disputed legal or political issues keeps that candidate from doing precisely what elections and campaigns are all about, right? There is exceptional tension, in other words, between the holding of a judge accountable under the Conduct Code's Announce Clause and a candidate's ability to campaign for judge. As you may be aware, in 1998, a Minnesota lawyer named Gregory Wursel, who was running for a seat on the Minnesota Supreme Court, filed a lawsuit contending that the Announce Clause violated his freedom of speech under the guaranteed by the First Amendment. Specifically, he contended that he was forced to refrain from announcing his views on disputed issues during the campaign to the point where he declined response to questions put him by the press and public out of fear that he might run afoul of the Announce Clause. Wursel was joined in his lawsuit by the Minnesota Republican Party that contended that because the Announce Clause kept Wursel from expressing his views, the party was unable to learn what his views were and so didn't know whether to support his candidacy or not. The freedom of speech provided by the First Amendment is, of course, one of our most cherished freedoms as Americans. And certainly freedom of speech protects at its very core political speech. Because freedom of speech is so critical to the very essence of our democracy, the law provides that any government regulation restricting freedom of speech is subject to what we call strict scrutiny, that is, subject to exacting review to see whether it is narrowly tailored to serve a compelling interest. Let's assume Wursel's freedom of speech was restricted. I treat this as an assumption because Minnesota never sought to discipline him for violating the Announce Clause. But let's assume that his freedom of speech was restricted. Was there a compelling state interest that justified the restriction? Minnesota was of the view that there was a double-barreled compelling state interest justifying the Announce Clause. First, the Announce Clause preserved the impartiality of the Minnesota judiciary, protecting the rights of litigants to a fair and impartial adjudication of their disputes. And second, the Announce Clause preserved the appearance of the impartiality of the Minnesota judiciary, instilling public confidence that Minnesota courts were fair and impartial. Now, I'd like to explore these two arguments in support of the constitutionality of the Announce Clause in a little bit greater detail, if you'll stay with me. It has been a long-standing tenet of judicial ethics that no man can be a judge in his own case. No man can be a judge in his own case. This starts, of course, with the idea that a judge cannot preside over a case in which he or she has a personal financial interest. It would extend too, wouldn't it, to cases of a close relative. In one case, the United States Supreme Court held that this principle prohibited judges from receiving a portion of the fines collected from defendants when found guilty. Why? Because such an arrangement gave the judge a direct, personal, substantial, and pecuniary interest in reaching a particular outcome, and thereby denied the defendant the right to an impartial judge. Minnesota contended that the justification for the announce clause follows from this principle. When a judicial candidate promises to rule a certain way on an issue that may later reach the courts, the potential for impartiality and fairness being disregarded is grave and manifest. If the judge fails to honor his or her campaign promises, he or she will not only face abandonment by supporters of his or her professed views, he or she will also risk being assailed as a dissembler, willing to say one thing to win an election and do the opposite once in office. Indeed, Minnesota's argument continued, a judge in this position therefore may be thought to have a direct personal, substantial, and pecuniary interest in ruling against certain litigants, for he or she may be voted off the bench and thereby lose his or her salary and emoluments unless he or she honors the pledge that secured the election. In writing about this point, the Chief Justice of my own court, Randall T. Shepard, has said that a campaign promise from a judge may be characterized as a bribe offered to voters to be paid with rulings consistent with that promise in return for continued employment as a judge. In short, Minnesota argued that the probability that campaign promises will prevent a judge from being impartial when confronted from ruling impartially on an issue that later reaches the judge's court so interferes with litigants' constitutional rights to due process of law as to outweigh the judge's constitutional right to freedom of speech. Minnesota's second justification for the announce clause, you'll recall, was that it preserved the appearance of impartiality of the Minnesota judiciary, instilling public confidence that Minnesota courts were fair and impartial. The argument went like this. Unlike the executive and even legislative branches of government, courts have little in the way of financial or police powers. If their rulings are to be respected and obeyed, the public must have faith in judges. As the United States Supreme Court once said, the legitimacy of the judicial branch ultimately depends on its reputation for impartiality and nonpartisanship. Minnesota contended that when a candidate makes a promise during a campaign, the public will no doubt perceive that he or she is doing so in the hope of garnering votes. And the public will in turn likely conclude that when the candidate decides an issue in accord with that promise, he or she does so at least in part to discharge his or her undertaking to the voters in the previous election and prevent voter abandonment in the next. The perception of that unseemly quid pro quo, a judicial candidate's promises on issues in return for the electorate's votes at the polls, inevitably diminishes the public's faith in the ability of judges to administer the law without regard to personal or political self-interest. I think these were pretty good arguments, but they were rejected by a 5-justice majority of the United States Supreme Court, which in a 2002 decision called Republican Party of Minnesota versus White held Minnesota's announce clause to be unconstitutional. The 5 justices in the majority did not take a specific position on whether campaign promises to rule a certain way violated due process of law. Rather, they said that the announce clause went well beyond a ban on campaign promises and commitments. Remember that the announce clause prohibited a candidate for judicial office from what? Announcing views on disputed legal or political issues. This includes statements beyond just promises, doesn't it? The proposition the Supreme Court majority wrote that judges feel significantly greater compulsion or appear to feel significantly greater compulsion to maintain consistency with non-promissory statements made during a judicial campaign than with such statements made before or after the campaign is not self-evidently true. It seems to us quite likely, in fact, that in many cases the opposite is true. We doubt, for example, that a mere statement of position enunciated during the pendency of an election will be regarded by a judge as more binding or as more likely to subject him to popular disfavor if reconsidered than a carefully considered holding that the judge set forth in an earlier opinion denying some individual's claim to justice. Now remember I said a few minutes ago that because freedom of speech is such a critically important constitutional right, any unit of government attempting to restrict free speech must what? Prove the restriction is narrowly tailored to serve a compelling state interest. The Supreme Court concluded in the White case that Minnesota had not met this burden of proving that campaign statements that did no more than announce a judge's views precluded them from being fair and impartial. The Supreme Court went on to argue that what Minnesota really seemed to be complaining about was that judges had to stand for election at all. For, the court said, any judge who makes a politically controversial decision runs the risk of being voted out of office regardless of whether the decision was consistent or inconsistent with a previously announced view on a disputed legal issue. I might say that the Supreme Court made this point with a sort of snide comment that I found off-putting. Surely, the court wrote, the judge who frees Timothy McVeigh places his job much more at risk than the judge who, horror of horrors, I'm reading from the Supreme Court right now, who, horror of horrors, reconsiders his previously announced view on a disputed legal issue, end of quote. Well, first, no judge ever freed Timothy McVeigh. Second, Timothy McVeigh was tried in federal court where judges are not subject to election anyway. The point could have been made, the same point, which has force, could have been made much better, in my view, by invoking Judge Horton's case, right? He was voted out of office, not for acting inconsistently with a campaign promise, but for providing Hayward Patterson due process of law. Anyway, after the White decision, states were no longer able to attempt to hold judges and judicial candidates accountable by means of announce clauses in their codes of judicial conduct. But remember the particular point of disagreement that the Supreme Court took with Minnesota's justification for the announce clause, that it went well beyond merely prohibiting campaign promises. Would a more narrowly drawn provision, one that prohibited only campaign promises to rule in a particular way, also violate freedom of speech? This question has not been decided by the Supreme Court, which has, in any event, 4 new members since the White case was decided. Let me tell you something of the contours of the current debate, shifting the focus from your state of Minnesota to mine own of Indiana. We did not have an announce clause in our Indiana Code of Judicial Conduct at the time of the White decision, and we have modified our language somewhat since then. Indiana prohibits judges and candidates for judicial office in connection with cases, controversies, or issues that are likely to come before the court from making pledges, promises, or commitments that are inconsistent with the performance of the adjudicative duties of judicial office. We defined the term impartial to mean absence of bias or prejudice in favor of or against particular parties or classes of parties, as well as maintenance of an open mind in considering issues that may come before the judge. This has become known as the commits clause. All right? I hope you can see that it is a much narrower restriction than the announce clause. Candidates are only prohibited from making pledges, promises, or commitments that are inconsistent with impartial adjudication. They're not prohibited from making statements on disputed legal or political issues unless those statements constitute a commitment to vote a particular way in a lawsuit. Now, an Indiana-based interest group and 2 judicial candidates have challenged the constitutionality of the commits clause. The interest group, Indiana Right to Life Incorporated, contends that the commits clause has the effect of prohibiting candidates from judicial office from answering its questionnaire on a variety of abortion-related issues, like whether they believe the right to life of human beings should be respected at every stage of their biological development, or whether Roe versus Wade was wrongly decided. When a judicial candidate does not answer these questions, Right to Life argues, it doesn't know whether to support or oppose the candidate. For their part, the 2 judicial candidates say that they would like to answer Right to Life's questionnaire, but fear that they will be punished by the Supreme Court for violating the commits clause. The plaintiffs filed this lawsuit in federal district court in Indiana. That court found that the commits clause did not violate freedom of speech. The plaintiffs appealed that decision to the Federal Court of Appeals in Chicago. I might say that the federal court system in this country is divided up by regions called circuits, so that appeals from the Federal District Court in Indiana go to the 7th Circuit headquartered in Chicago, and appeals from the Federal District Courts in Minnesota go to the 8th Circuit headquartered in St. Louis. In any event, the decision of the Court of Appeals was written by Chief Judge Frank Easterbrook, a very well-known figure in American law. He reached the same conclusion as had the district court, that the commits clause did not violate freedom of speech. In fact, he wrote that on the surface, the plaintiff's argument seemed far-fetched. How could it be permissible, he asked, to make pledges, promises, or commitments that are inconsistent with the impartial performance of the adjudicative duties of judicial office? Quoting from some other district courts, Judge Easterbrook said that a commits clause secures a basic objective of the judiciary, one so basic that due process requires it, that litigants have a right to air their disputes before judges who have not committed to rule against them before the opening brief is read. And from another case, judges must decide on the basis of the law and the case's facts, not on express commitments that they may have made to their campaign supporters or to others. Judge Easterbrook continued that although the Supreme Court held in the White case that judges may state their views on contestable and controversial subjects, It did not hold that judges may make commitments or promises about behavior in office. Imagine a judge or judicial candidate who said, "I will issue a search warrant every time the police ask me to." The Speaker is promising to defy the judicial oath of office. Or imagine a statement, "I will always rule in favor of the litigant whose income is lower so that wealth can be redistributed according to the principles of communism." More plausibly, a candidate might say that he will award damages against drug companies whether or not the drug has been negligently designed or tested because drug companies charge too much for their products. Again, that person is promising to disobey the law and disregard the litigant's entitlements. Nothing in the Supreme Court's opinion in the White case, Judge Easterbrook said, deals with statements of this flavor or any other promise to act on the bench as a partisan of a political agenda. Now this, of course, is music to the ears of supporters of the Commits Clause, of whom, of course, I am one. Remember that the Commits Clause, at issue in this case, is part of the Indiana Code of Judicial Conduct promulgated by the Indiana Supreme Court, of which I am a member. I voted for it. But I would be the first to acknowledge that things are not quite as simple as the sentences from Judge Easterbrook's decision that I have just quoted. And, of course, Judge Easterbrook himself recognized that the plaintiffs had a point when they argued that a good deal of what makes the Commits Clause constitutional is the phrase, "inconsistent with the impartial performance of judicial office." What does that mean? The plaintiffs contended that this phrase is too vague to permit the regulation to stand. What promises are inconsistent with the impartial performance of the adjudicative duties of judicial office? Neither the Commits Clause nor the Code's definition pin the meaning down. The plaintiff's contention here, as you can see, is that the Supreme Court of Indiana may treat as inconsistent with the impartial performance of judicial duties even the sort of statements that are squarely protected by the Supreme Court's decision in the White case. But Judge Easterbrook was unwilling to declare the Commits Clause unconstitutional on these grounds. Rather, he said, the best way to find out what the Indiana Supreme Court is going to do is wait and see. Plaintiffs want us to deem the law vague by identifying situations in which state officials might take an untenably broad reading of the Commits Clause and then predicting that they will do so. It is far preferable, however, Judge Easterbrook wrote, and more respectful of our judicial colleagues in Indiana, to assume that they will act sensibly and resolve the open questions in a way that honors candidates' rights under the First Amendment. The bottom line today, in Indiana at least, is that a candidate for judicial office is free to announce views on disputed legal or political issues, but cannot make pledges, promises, or commitments that are inconsistent with the impartial performance of the duties of judicial office. A judicial candidate can announce, but can't commit. Now, all of this has been a little theoretical. While there are real candidates for judicial office in the Minnesota and Indiana cases we have been talking about, neither Minnesota nor Indiana has attempted to discipline them. We've been talking a lot more about abstract principles of law than nitty-gritty politics. But there is nothing theoretical or abstract about what has been happening in judicial elections around the country since the Supreme Court's decision in the White case. Let me tell you a few stories from our part of the country. In 2004, 2 years after the White case was decided, 2 candidates for the Illinois Supreme Court, believe it or not, spent $9.3 million on a state Supreme Court race. Trial lawyers wrote six-figure checks to the Democratic Party of Illinois, which contributed about $2.8 million to the campaign of Judge Gordon Magg. Magg received another $1.2 million from a political action committee consisting of plaintiffs' personal injury lawyers and labor leaders. Meanwhile, the U.S. Chamber of Commerce sent $2.3 million to Judge Lloyd Carmier's campaign through the Illinois Republican Party, the Illinois Chamber of Commerce, and a political action committee supporting what was called tort reform that also received $415,000 from a national tort reform group. Finally, Carmier received more than $350,000 in direct contributions from employees of State Farm Insurance. While this campaign was underway, a multi-million-dollar jury verdict against State Farm was pending, where? Before the Illinois Supreme Court. Sort of sounds like the John Grisham novel, The Appeal, doesn't it? After the election, the case was decided in favor of State Farm by a 4-3 vote, with newly elected Justice Carmier casting the deciding vote. In Ohio, candidates for the Ohio Supreme Court have raised $18.7 million in the last decade. In their most recent election or re-election campaigns, 6 of the 7 members of the court raised at least $1 million. One was unopposed. During this period of time, an examination of the Ohio Supreme Court by the New York Times found that its justices routinely sat on cases after receiving campaign contributions from the parties involved or from groups that filed supporting briefs. On average, they voted in favor of their contributors 70% of the time. In Michigan, the 2008 race between a Republican incumbent Chief Justice and a Democratic challenger was characterized as the dirtiest of the 26 high court contests in 15 states that year by a national judicial reform organization. Television ads run by the incumbent's supporters described his opponent as soft on terrorists and sexual predators, while ads aired on behalf of the challenger depicted the sitting Chief Justice as a pawn for big business and as literally sleeping on the job. The incumbent raised $1.9 million, the challenger $750,000. Special interests paid for nearly 3/4 of the TV ads in this campaign. In West Virginia, we encounter perhaps the worst story of all. The story actually starts all the way back in 1998 when Harmon Coal Company sued Massey Coal Company, claiming that Massey had used fraudulent business practices to destroy Harmon. In 2002, the year of the White decision, a West Virginia jury agreed, awarding Harmon $50 million in damages. In 2004, while the case was on appeal, Massey CEO Don Blankenship spent $3 million on an independent campaign to elect lawyer Brent D. Benjamin to the West Virginia Supreme Court. This accounted for 60% of all money spent on Benjamin's behalf. Benjamin was elected, and in 2007, guess what? Justice Benjamin cast the deciding vote in a 3-2 decision to overturn the jury, and in a second 3-2 decision to overturn the $50 million judgment. These 4 stories are part of a national trend over the past decade from which I draw 2 related inferences. First, interest groups believe that, and have reason to believe that, it is worth a substantial investment in campaign contributions to support particular candidates for judicial office. Second, more subtly, the efforts of courts like my own to protect the fairness and impartiality of judges by prohibiting them from making pledges, promises, or commitments does not appear to be working. I will concede, for purposes of argument, that the Supreme Court was correct in its White decision to conclude that a candidate's announcing views on disputed legal or political issues does not create the direct, personal, substantial, and pecuniary interest necessary to violate due process. But by making such pronouncements on the campaign trail, the candidate signals courtroom rulings in a way that generates significant campaign contributions and other support. In my view, the receipt of such campaign contributions and other support does create a direct, personal, substantial, and pecuniary interest that does violate due process. In an odd sort of way, it seems to me that the Supreme Court agrees with this analysis, even though it appears contrary to its decision in the White case. Let me tell you why I say that. I told you a few minutes ago the story of Justice Benjamin's campaign support from Massey Cole and Benjamin's subsequent votes on the West Virginia Supreme Court in favor of Massey. There's more to the story. When the West Virginia Supreme Court vacated the $50 million verdict against Massey Cole, the plaintiffs in the case asked the United States Supreme Court to reinstate the verdict. Now, not every decision made by a state Supreme Court, thank goodness, is subject to review by the United States Supreme Court. When the West Virginia Supreme Court, or the Indiana Supreme Court, or the Minnesota Supreme Court rule on issues of state law, our rulings are, if I may say so, supreme and not subject to further review by the United States Supreme Court. It is only when we have ruled contrary to federal law, as opposed to our own state's laws, that the United States Supreme Court can overturn our decisions. The plaintiffs suing Massey Cole, therefore, were required to contend that the West Virginia Supreme Court had acted contrary to federal law in overturning the $50 million judgment. Their argument will sound very familiar to you, as it has been a central theme in our discussion this evening. That's right. The plaintiffs contended that their constitutional right to due process of law was violated because Justice Benjamin was not fair and impartial in ruling on their case. They argued that he should not have acted as a judge in the case, that he should have disqualified or recused himself. Now, for the most part, the Supreme Court has left to state statutes and judicial codes of conduct the question of whether a judge is disqualified from hearing a case because of bias or prejudice. But at least as long ago as 1975, the Supreme Court concluded that there are circumstances in which the probability of actual bias on the part of the judge is too high to be constitutionally tolerable. The question was whether Justice Benjamin's was such a circumstance. The Supreme Court's analysis was quite interesting. First, it noted that Benjamin himself reported having conducted a probing search into his actual motives and inclinations and concluded that he could decide the Massey Cole case impartially and fairly. The Supreme Court said that it did not question Justice Benjamin's subjective findings of impartiality and propriety. Nor, for that matter, did the Supreme Court determine that there was actual bias on Justice Benjamin's part. Rather, the Supreme Court said the difficulties of acquiring into actual bias simply underscore the need for an objective rule. The objective rule promulgated in the Massey Cole case was this: there is a serious risk of actual bias when a person with a personal stake in a particular case had a significant and disproportionate influence in placing the judge on the case by raising funds or directing the judge's election campaign when the case was pending or imminent. The inquiry centers on the contribution's relative size in comparison to the total amount of money contributed to the campaign, the total amount spent in the election, and the apparent effect such contribution had on the outcome of the election. Well, with this test, you will not be surprised to hear that after applying this principle, the Supreme Court concluded that here there was a serious objective risk of actual bias that required Justice Benjamin not to participate in the case. If you click down each of these 4 criteria, you see they were all present in the Massey Cole case. Okay. The Supreme Court says that it does not violate due process for a judicial candidate to announce views on disputed legal or political issues. That's the White case. But in the Massey Cole case, the Supreme Court says it does violate due process for a judge to rule in a case involving a disproportionately influential campaign contributor. I say that disproportionately influential campaign contributions will only be made to the judicial candidate if the candidate's announced views signal how the candidate, if elected, will vote in litigation of interest to the contributors. So while announcing views itself is constitutionally protected, that protection may disappear, as it should, if one of the consequences is to generate a disproportionately influential campaign contribution from a person with a personal stake in a pending or imminent case. Now, I don't know about you, but for me, all this seems to be pounding a square peg into a round hole. Judicial candidates cannot promise to decide cases in a particular way, but they can announce their views, and if the announcement of their views generates disproportionately influential campaign contributions, they can't later be judges in the case. I say, once the announce clause, I, Sullivan, say, once the announce clause was held unconstitutional, the genie was out of the bottle, the mercury was out of the vial, whatever your favorite metaphor is. Judicial candidates could now signal how they would decide cases as long as they didn't commit. For example, even Judge Easterbrook, in his decision upholding the commits clause, said that state Supreme Courts couldn't prohibit judicial campaign statements like, judges have been too ready to find antitrust problems with mergers, or mandatory minimum sentences are unjust, and I will read those statutes narrowly. No commitments there in either of those sentences, but that's plenty of information, I think, from which a big contributor can conclude that the financial support of the candidate would be a good investment in the outcome of future litigation. So what's the answer? How do we assure judicial fairness and impartiality in the post-White era? Some people think the answer is to increase the robustness of judicial disqualification and recusal rules. Picking up from Massey Cole case's requirement that Justice Benjamin recuse himself because of the contributions he had received, various entities within the American Bar Association, something called the Justice O'Connor Project at Georgetown Law School, the American Judicature Society, a prominent law school dean named Erwin Chemerinsky, argue that strong recusal rules are the antidote to unfettered judicial campaign speech and the big money campaigns that accompany it. Everything is fine if only the judge doesn't participate in the case in which he or she has announced its view, his or her views. Just as with the commits clause, I support robust recusal rules. But just as with the commits clause, I don't think robust recusal rules solve the problem. First, as my own Chief Justice, Randall Shepard, wrote before the White decision, the notion of recusal as the solution to bias from campaign speech is disingenuous because it disconnects free and unfettered campaign promises from any possibility that they'll be carried out. Advocates of recusal reform, like Professor Charles Jay of Indiana University's Maurer School of Law, believe that tough recusal requirements will prevent judges from announcing their views during campaigns because they will not want to be precluded from participating in cases once elected. Some judicial candidates might engage in such a calculus, but I don't think this is likely. It seems to me that it is far more likely that the candidate's priority during the campaign will be on saying what's necessary to get elected, not avoiding behavior that may require them to recuse after the election. So my bottom line is that efforts to bolster recusal will not solve the threats to due process caused by the White decision and big money influence on judicial elections. In Indiana, we have a system in place since 1970 to select members of our appellate courts and hold them accountable that does not utilize partisan or contested elections. When there is a vacancy on the Indiana Supreme Court or Indiana Court of Appeals, interested lawyers and judges submit applications to the Indiana Judicial Nominating Commission, a 7-member body consisting of 3 lawyers elected by the lawyers of the state, 3 non-lawyers appointed by the governor, and the Chief Justice of Indiana, who chairs the commission. Following the completion of interviews and background checks, the commission selects 3 applicants it considers best and submits those 3 names to the governor. The governor must appoint from among those 3 applicants. After the new judge takes his or her seat, that judge serves for 2 full years and then stands for a statewide yes-no retention vote at the next statewide general election. We think this judicial selection and accountability system is superior to contested election systems because the involvement of the Chief Justice and representative lawyers on the commission and the public nature of the process help assure that people of integrity, impartiality, and intelligence are appointed. The involvement of the governor and non-lawyer commission members and periodic retention votes help assure accountability. And the absence of contested elections helps assure that there is no perception that justice in Indiana is for sale, no perception that lawsuits are decided in response to party or interest group contributions. Ooh, how'd that happen? Well, that was sort of a dramatic point, and it sort of failed, didn't it? There we go. I was so emphatic that I blew up the whole system. But that's what I want to do. I want to blow up the existing system. I know this has been a topic of debate here in Minnesota, where the Citizens Commission for the Preservation of an Impartial Judiciary, chaired by former Governor Al Quie, examined the issue of whether and how Minnesota's method of selecting and retaining judges should be changed following the Supreme Court's decision in the White case. It is my understanding that the Quie Commission recommended that judges be appointed by the governor from a slate of candidates nominated through the merit selection process, and that judges' terms would be renewed through retention elections. I am told that the Commission believed that expanding the merit selection process to all judges would promote high-quality, impartial judiciary. Comprehensive performance evaluations of all judges would promote self-improvement, quality, and impartiality. And by giving voters the information they need to cast an informed vote, performance evaluations would promote accountability. In addition, renewal of judges' terms through retention elections would expand public participation in the renewal process and promote accountability of all judges. I endorse the recommendations of the Quie Commission and call on all of you to work for their enactment. Now, many of you are aware that in your neighboring state of Iowa, a similar system is used to that in our state and that recommended by the Quie Commission. And you know that last fall, 3 members of the Iowa Supreme Court stood for retention vote and received a majority of negative votes. The reason they were removed from office was because of their support for a decision holding that a ban on gay marriage violated the Iowa Constitution. I think this result was unwarranted and regrettable. The retention vote process is meant to provide a measure of accountability, not to be used for removing judges for rendering decisions that are politically unpopular. But this unfortunate result does not change my belief that the merit selection retention vote system of judicial selection and accountability is superior to contested elections. The fate suffered by the Iowa justices would have been possible under a contested election system, as Judge Horton's unfortunate experience demonstrates. But the 3 new justices who will take their place will be selected on the basis of their merit, not on the basis of their ability to win votes after announcing their views on disputed legal or political issues, their ability to raise or attract substantial campaign financing, or their use of negative attack advertising. Our system in Indiana, which, as I say, has been in place for 40 years, has served us well. I think what the Quie Commission has recommended would serve your state well also. Let's go back to the beginning. None of us knows for sure when we might find ourselves in court, seeking to vindicate our legal rights or seeking protection for our nearest and dearest interests. The United States Constitution guarantees that when we do, we will be the beneficiaries of due process of law. As citizens, we must all think about how we assure that due process of law is available for us when we need it, and for our fellow citizens as well. I have discussed with you tonight how the systems set in place by the highest courts of every state to assure judicial fairness and impartiality by enforcing codes of judicial conduct have run afoul of judicial candidates' freedom of speech in contested elections. We have seen that the current state of the law, while allowing judicial candidates to announce their views on contested legal and political issues, has not been extended to permit judicial candidates to make pledges, promises, or commitments as to how they will vote in particular cases. But we have also seen that, at least concomitant with, if not caused by, the Supreme Court's decision in the White case, huge sums of special interest money have poured into judicial elections, some in such significant ways as to require judicial recusal, while some have suggested that robust recusal regimes are the antidote for judicial campaign practices that impinge upon fairness and impartiality. I advocate a movement away from contested elected systems altogether, a movement to a system like we have in Indiana, a system like that recommended by the Quay Commission. I hope you will reflect upon my recommendation and take it to heart. Thank you very much for your kind attention.
Curious, you say, you commented that the result using a merit selection for secret abstention votes in the Iowa situation was regrettable, that these people were not retained. And similarly, I don't think Judge Horton would have been retained in his situation. I mean, it was like, Ferguson was against him, whether it's contested election or abstention election. And you said it's regrettable, but at the very least, they'll be replaced by people of merit in the system. But I think, as regrettable as that is, it seems like it would be more regrettable if fear of the result of a retention election led a judge to change their ruling and do something different. So I guess my question is, why have a retention election at all? Why not just appoint them and have them responsible for periodically to a merit selection? Why not? I think that's a highly respectful point of view, and of course that's the view
Reach right in writing the United States Constitution. Federal judges are nominated by the President, confirmed by the Senate, and serve on good behavior for life. I think that a little bit of why I say what I say is just maybe a reflection of political pragmatism that I think it would be highly unlikely in a country where 39 states have elections for judges to be able to make a sale that judges ought to have life tenure. But I also think that there is something to having accountability properly construed. You'll hear from time to time comments about the behavior of federal judges, which, while not rising to the level of impeachable offenses, still represents a little bit of a disconnect from the way we would want judges to behave. And I would see myself, and I've run for retention twice, when I've run with maybe one or two occasions, the subject of particular rulings that I've made have not been discussed. But if I had the reputation of being a lot more arrogant than I am, we have an expression in the judiciary, black robe-itis, have an idea what that is. If I was suffering from black robe-itis, or my attendance was very poor, I was constantly missing votes at the court, or engaged in some behavior like Judge Anselmo. Those are the kinds of things for which I ought to be held accountable. And those are the kinds of things for which life tenure judges really aren't held accountable. There are some federal judges who engage, probably Judge Anselmo, were he a federal judge with life tenure, would be impeached by the Congress, by the Senate. But some behavior of lesser abhorrence than that, there's something to be said for having a degree of accountability. And it's sort of the obverse of what you say. I'm going to come to work Monday through Friday. I'm not going to miss any votes. I'm going to turn my opinions out on a regular basis. Because when I stand in front of the voters, I want the voters to say, we want to retain Sullivan because he's proved to be hardworking and productive and has comported himself in the way that we would like a member of our Supreme Court to behave. But there's sort of a risk either way. And maybe the risk you describe, that is to say someone being fearful of voting in a particular way in a particular case because they're going to be voted off, is a worse risk than some federal judge suffering from black robitis. I think that's a respectable argument. But those would be sort of the two things. It's a purely pragmatic matter. I don't think that states are going to give me life tenure. And then second, accountability is not all bad. Keeps me on my toes, keeps me going to work Monday through Friday, keeps me current on my cases, and that's good too. But I cannot dispute the logic of your position.
Frank, can you give us a little history of it further back? Have we ever had life appointments at the state level? Which way is it?
Yeah, well, I would say that the trend at the moment it's been pretty static. I'm not a great expert on this, but most of the original colonies have, like the federal system, life tenure appointments. The New England states, those judges have, if not life tenure, at least tenure until a mandatory retirement age, something like that. And then about the time of the age of Jackson, where you had sort of a populist revolt in the country, there was a backlash against unaccountable judges, and contested elections came in. In my own state of Indiana, our state constitution took effect in 1816, and the judges were appointed by the governor, and there was no election. And then we had, unrelated to the subject we're talking about tonight, we had a constitutional convention in Indiana in 1851, and the old Constitution was thrown out. The new Constitution came in providing for the election of Supreme Court judges, and it was a reflection of the Jacksonian age. And then in the, I would say roughly the middle of the 20th century, there was a concern about the election of judges, and the system that I described that we have first came in the state of Missouri, and most people who talk about this describe this merit selection retention vote system as the Missouri plan. And ours is slightly different than Missouri, but I'm not sure. At one point I knew precisely how we differed. I'm not sure I could recite that now. And that took hold for the middle part of the 20th century, and there are quite a few states that are Missouri plan states, like Iowa and Missouri and Indiana and Tennessee and Nebraska. California are all states that I'm aware of. They're that. But I would guess that from, probably the 1980s on, nobody else has changed. The Deep South is steeped in Jacksonian democracy, very, very strong commitment to elections. And I could have told you a comparable set of horror stories from Texas and Alabama to the one that I told you from the Midwest over sort of the same period of time, maybe actually predating White a little bit. So I would say that that's sort of the rough equivalent of it. And my guess is that if I probably should have memorized these statistics. In fact, I do have them with me as to what states have what. I think you basically see the New England states where the judges are immune from any kind of voting. A chunk of states, maybe a quarter of them with a Missouri plan, and the balance that's still elect. And there are some variations, like your system here, you have contested elections, but the candidates don't run with their party affiliation noted. Although the fact that the Republican Party of Minnesota was a party in the White lawsuit tells me that the parties here are intensely interested who the candidates are, even if they don't carry a Republican or DFL label. Yeah.
I agree with your view of these things, but let me ask a devil's advocate question, partly out of my ignorance of the law. The question basically is, what is a promise or a commitment? So let me put it this way. Have you tonight made to us any promises or commitments that might jeopardize your role in a case? Does it make a difference that it's here and not in Indianapolis? Does it make a difference that you're not in a campaign at this point, et cetera, et cetera? But if it happened in a campaign in Indianapolis, have you made a promise or a commitment tonight that would recuse yourself from a case?
I would say that I have not made a promise or a commitment, and I'll explain that in a minute. But I have certainly expressed a view on a disputed legal and political issue. And if I were running in a contested election, you'd know whether you wanted to put your money on me or not, because you know exactly where I am on this issue. But I don't think that I have expressed a view on the outcome of a particular case. I suppose the question you would ask is, have you, Sullivan, expressed a view on whether your commits clause violates the First Amendment? I don't think there was anything in my speech that I said that expressed my view as to whether or not the commits clause violates the First Amendment. I did say that Judge Easterbrook's analysis was music to my ears, but I didn't say that he was right, and I didn't commit to rule the same way he did. However, in some ways, so this is sort of the line that you know, while I'm all for, this is a principal point of my talk, right? I'm all for commits clauses. I don't think people ought to make commitments. But I'm not sure there's that much functional difference between an announce clause and a commits clause. That's just one of them. But here's another point about me personally. In some ways, I've already declared myself on this because about 4 or 5 years ago, the members of the Indiana Supreme Court sat down deliberately, the 5 of us, and said, what are we going to say in the Indiana Code of Judicial Conduct about campaign speech? And we said, we're going to prohibit promises, pledges, and commitments. And I voted for that. I'm on record as having voted for that. And given my oath of office, I could not have voted for that if I thought that violated the United States Constitution. So in a sense, I guess I would say I've already, to the extent that I'm guilty of making a commitment tonight, I've made no more a commitment than I did when I voted on the matter by voting for the rule. But I hope that maybe helps illustrate the point I'm trying to make tonight of just how difficult it is in practice to distinguish between. Well, I think you can, as a matter of logic, distinguish between announcing and committing. But the practical effect, I think, is going to be pretty much the same. Once I've announced, and I'm out looking for campaign contributions, you're going to be smart enough to know whether you want to put your money on me or on my opponent. And that's why I think, you know, and then the fact that I'm going to recuse myself later on, well, it's a nice idea, but I want to get elected. And I'll either, if I recuse, the people who supported me will be ticked off because their investment didn't pay off, but I don't know that that helps the system that much. And And it just, I see a lot of, this recusal stuff may sound awfully technical to you, but I see a lot of people in my business right now really putting in a lot of time and energy on trying to, you know, make the recusal remedy so much stronger and all. And I would just soon see that energy go to trying to move to merit selection systems.
I have a question. Given, as soon as there's this much money involved, does it even matter if the commitment is made publicly? Let's suppose in the case of the Massey Cole case, that the candidate that's supported has never publicly said he's good. It's just that he just needs to say something in passing to the CEO of Massey Cole, or he could not say something, but it's understood. So it really seems that there the problem is not, the problem is the money, not necessarily any public campaign pledge that we made.
I agree with that. And in fact, there's a little bit of paper trail of Justice Benjamin, you know, defending himself, saying, I voted against Massey in a whole bunch of other cases, and things like that. And I never said anything about Massey Cole or this case in my campaign. And so in that respect, you're right. Whatever the rules may be on announce or commit may not matter at all. But part of the problem here is just, for whatever reason, there's a lot of money coming in. And I take your point to be, even if we didn't have any of this debate over announce or commit, we still would have a lot of money coming in. And you may be right about that. And in fact, I mentioned a few minutes ago, a lot of these big bloodbaths in Texas and Alabama occurred before the White decision. But I would still say that even if the White decision did not precipitate this flow of big money, we still would be better to move away from judicial elections, just because they seem to be a magnet for interest groups. You know, if I'm State Farm and I've got $50 million at stake, put $500,000 into a judicial campaign, you know, what the heck? I'm going to be spending that much on lawyers anyway. I might as well put my money on somebody who's likely to be far more productive to me than my lawyers, and that's a judge who's going to be sitting on the case. And if he votes against me, well, I think Carmeier is more likely to vote for me than Mag is, so I'll put my money on Carmeier. And then, I mean, there are different ways to give this speech. I have found the debate over the announce clause and the commits clause to be pretty interesting. And you did ask me to fill up close to an hour. If I just come in here and said, let's go to elected systems, you wouldn't have thought I kept my commitment to you.
Okay, well, we're at 9 o'clock now, so we're going to wind it up. Thank you. This is a very interesting talk, and has left me very worried, but maybe for those of you who are reassured by the end, I'm now worried about all the maps you put up there.
Are there, like, I'm from Texas, so, and I know that, and I'm aware of the partisan campaign, that it's even in a partisan primary, even in parties. So are there commissions down in the South or are anywhere in the country that want to go to this selection?
There was a man who was the Chief Justice of your Supreme Court named Tom Phillips, probably the mid-90s to 2004, 2005, who very courageously fought for merit selection in Texas and got absolutely nowhere, and resigned his seat some years ago and is now in private practice law in Washington, D.C. You know, I would say that if you looked into the work that Chief Justice Tom Phillips did, himself a product of the elected system down there, and yet came to believe that it was corrupt, and fought very much for it, and finally, I think, concluded that he was banging his head against the wall, or that he wanted to put a little more meat and potatoes on his family's table at night, or whatever left the bench. And you do see courageous people rising up. I'm not currently aware, but as I say, I've not done a systematic study of this. There is an organization called the American Judicature Society, headquartered, ironically enough, in Iowa, that is probably the nation's leading source of data and information on this subject. And if you went to the HAS website, you could find out precisely what's going on in each state. Thank you all. Appreciate your time.